Welcome to the deep dive. You've brought us a dense stack of sources today on a topic that might seem straightforward, family law,
Yeah,
but which actually hides one of the UK's most complex geographical puzzles.
that's right. That assumption of uniformity is exactly where the deep dive begins. When it comes to family breakdown, the United Kingdom, well, it's not a single
Not
entity.
at all.
We are dealing with three completely separate legal systems or jurisdictions. You've got English law for England and Wales, you have Scots law, and then Northern Irish law. And they're fundamentally distinct.
So our listener wants to move beyond that surface level and, gain a thorough, nuanced understanding of how these three systems handle the breakdown of relationships,
Yeah.
particularly when it comes to money and children. The mission today is to cut through all that complexity and really map out those key disparities.
And we have to ground this in the concept of devolution. Since 1998, devolution has granted nations like Scotland and Northern Ireland the power to craft their own legislation in specific areas. So while Westminster retains control over, say, reserved matters like defense, family law is devolved. And that means the rules governing your divorce, your cohabitation rights, and your children's welfare can change dramatically just by crossing a border inside the UK.
Okay, let's unpack this. Starting with the one legal misconception that I think traps more people than any other,
Common law marriage.
the myth of common law marriage.
It is arguably the most damaging public misconception in UK law. I mean, you have over 3.5 million couples cohabiting in England and Wales.
Wow.
And an alarming number of them believe that after a certain period, they just, automatically acquire the same legal protections as people who are married.
And that belief, unfortunately, provides zero protection in the largest jurisdiction.
Precisely. In England and Wales, cohabitants have no general legal right to financial support from their ex-partner. None. Nor do they have an automatic share of property if they weren't legally named on the title deeds.
So when the relationship ends,
The financially weaker partner is left with extremely limited recourse.
what little recourse there is in England and Wales, it relies on property law, not family law. Is that correct?
That's right. The main way they can seek an interest in the home is through something called the Trusts of Land and Appointment of Trustees Act, 1996. TOLATA, for short.
Right.
This lets a cohabitant argue they have an equitable share in the property based on, implied agreements or contributions like paying the mortgage or funding renovations, even if they're not the legal owner.
But that sounds complicated.
It's complex, it's expensive, and it's far from guaranteed protection. They can also seek financial support, but only for the children, via Schedule 1 of the Children Act, 1989.
So living together in London is a huge financial gamble compared to, say, Glasgow.
Absolutely. Scotland is the real outlier here. Scots law uniquely offers certain legal rights and responsibilities to cohabitants. That's under the Family Law Scotland Act 2006.
So what does that act do?
These rights allow the economically disadvantaged cohabitant to seek a fair share of assets or compensation upon separation. It offers a degree of safeguard that simply doesn't exist south of the border.
That is a fundamental difference. And it's driven, in part, these urgent calls for reform in England and Wales.
Oh, it's a massive driving force. The government is pushing for major modernization of family law in England and Wales, with a consultation scheduled for spring 2026.
And that's aimed specifically at this issue.
Yes, aimed at addressing this cohabitation myth and introducing, consistency and fairness across different relationship types.
So until that potential reform happens, the advice is universal, isn't it? Protect yourself with a contract.
Always. Given the lack of default legal protection across the UK, especially for property and finances, legal documents like cohabitation agreements are crucial.
Sometimes called living together agreements.
Exactly. Those and declarations of trust. They define your arrangements before the worst happens, which, well, that's the only real certainty cohabitants have at the moment.
Okay, so the differences in cohabitation are striking, but the divide deepens when we look at marriage and divorce settlements.
Spousal maintenance.
Right, particularly spousal maintenance. We are moving right into the sharp contrast between financial flexibility and the strict requirement for a clean break.
Well, spousal maintenance is, simply an ongoing payment to support an ex-spouse who can't financially support themselves after the divorce. The key distinction, as you said, rests on this clean break principle.
Who's the idea that?
The idea that, where possible, a divorce should create a definitive financial endpoint, so neither party remains dependent on the other indefinitely.
Here's where the three jurisdiction split creates dramatic differences in personal financial planning. Let's look at the duration of these payments.
This is where England and Scotland just diverge completely. In England and Wales, it's governed by the Matrimonial Causes Act 1973. Spousal maintenance there can be paid, well, for as long as necessary.
In-depth.
Potentially. While the courts are encouraged to consider a clean break, they have the power to impose maintenance for an indefinite period, even for life.
But Scotland takes a far firmer line on dependency.
It does. The Family Law Scotland Act, 1985, places clear restrictions on the payment period. Maintenance is capped at a maximum of 3 years.
Just 3 years.
A maximum of 3 years, unless there are truly exceptional circumstances. This Scottish approach, it reflects a deep philosophical commitment to that clean break principle. It mandates a rapid transition to financial independence.
If the goal in England is supposedly this clean break, why did the courts keep the door open for claims years later in the first place? I mean, this brings us to the case of Wyatt v. Vince.
Ah, yes. Wyatt v. Vince perfectly illustrates the unique risk of the English system. Mrs. Wyatt successfully brought a financial remedy claim against her ex-husband, Mr. Vince.
Who had become a millionaire.
A millionaire in the energy sector, yes, long after their marriage ended. Crucially, she was successful in bringing that claim almost 2 decades after their divorce.
Wait, so even though they divorced decades ago, the Supreme Court ruled the financial relationship wasn't technically closed. That seems fundamentally unfair to the high earner.
Well, the Supreme Court found that because they had never obtained a final consent order from the court to dismiss all potential claims, which is a routine but essential step, the claims technically just lingered.
Like a legal zombie.
Exactly. For years. This flexibility in England, or the uncertainty it creates, is often criticized because it exposes people to litigation many, many years down the road.
And the most important insight here is that the Wyatt v. Vince ruling has zero application in Scotland.
Correct. The 3-year cap in Scots law simply prevents those decades-later claims. That difference is fueling the conversation in England about whether clearer, shorter time limits should be imposed.
For certainty.
To bring certainty to financial planning, yes.
We should also note the small but significant difference in Northern Ireland regarding buying out a maintenance claim. That adds another layer of jurisdictional nuance.
That's about achieving finality through a lump sum. So if one party wants to resolve their maintenance obligation with a single buyout payment, in Northern Ireland, both ex-partners must formally agree to it.
Both have to agree.
Yes. But in England and Wales, the court holds the power to impose a lump sum buyout, even if the recipient would prefer ongoing monthly payments.
Ah, so the English court has more power there.
It gives the English court greater power to finalize the financial relationship definitively when one spouse has sufficient capital.
Now let's pivot to children's issues. The welfare of the child is paramount everywhere, but the process of listening to the child's voice, that shows subtle but important differences.
The overarching principle is enshrined in law across the UK. The paramount concern is always the welfare of the child. But how the court ascertains that welfare, especially the child's own wishes and feelings, that varies.
So how does the child's voice factor into decisions in England and Wales?
The court uses the welfare checklist, which is in the Children Act 1989. The child's wishes are considered based on their age and their understanding.
And how do they find that out?
They use Cafcass, the Children and Family Court Advisory and Support Service. Cafcass officers conduct safeguarding checks and, crucially, write what are called Section 7 reports.
And that involves meeting the children.
Yes, it requires meeting the children and parents separately to assess the child's lived experience and their preferences.
And Scotland's, that's a very clear marker for maturity.
It does. Scots law establishes a strong presumption. A child of 12 or more shall be presumed to be of sufficient age and maturity to express their views to the court.
But it's not the deciding factor.
No, the child's view is considered, but it's generally not determinative. The judge still applies the welfare principle. That said, as children get into their mid-teens, 14 or 15, the practical weight of their views increases significantly.
Why is that?
Because realistically, they can vote with their feet if a court order is deeply unpalatable to them.
It sounds like the overall direction of travel, though, is toward ensuring children feel heard, even if they aren't making the final decision.
Precisely. We are seeing new mechanisms aimed at increasing participation. For example, in England, the Child Arrangements Program now allows for an informal meeting between the child and the judge.
The child meets the judge.
Yes. often with a Cafcass officer present. Crucially, the discussion is not treated as evidence in the formal proceedings. It's purely designed to involve the child, make them feel less like an object of the dispute, and hopefully increase their investment in whatever order is made.
And before we move on to the massive topic of access to justice, quickly, how are the court structures different?
They reflect the devolved nature of the law. So in England and Wales, you go to the specialist family court.
Right.
In Scotland, it's usually the sheriff court. And in Northern Ireland, initial applications often go to the family proceedings court, with more complex or high-value cases transferring up to the family care center or even the high court.
Right. Let's talk about the cost of accessing these systems. Focusing on legal aid in England and Wales, the system is now, it's designed to exclude most general family disputes.
It is.
And that's led to a huge rise in people representing themselves.
Absolutely. Legal aid is meant to be the government-funded safety net, providing advice, mediation, representation for those who can't afford it. To qualify, you have to pass two stringent tests, the financial means test and the merits test.
Detail those primary restrictions for us.
Well, after the 2013 cuts, general divorce, standard financial settlements, and most private law children matters are simply not covered. They're out of scope.
So when do you qualify?
You only qualify if the case involves specific serious issues like child protection proceedings, forced marriage, child abduction, or, significantly, if you can prove you are a victim of domestic abuse. And that evidence has to be from the last 2 years.
And even if you can prove domestic abuse, the financial hurdles are still incredibly high. Give us the hard numbers on that means test.
The gross monthly income threshold for eligibility is generally capped at 2,657 hours.
That's not a lot.
No. And while certain benefits might automatically pass the income part of the test, your capital limits, so savings and property equity, they still apply. That 2,657 threshold means that someone earning slightly more than the average salary, maybe working 2 minimum wage jobs, is just locked out of protection.
And that means a person can be trapped in a controlling situation, a victim of abuse, yet be denied legal aid simply because their gross income is fractionally too high.
That is the cruel reality of the catch-22 created by the current rules. The high cost and complexity of the system, coupled with the lack of legal aid, is pushing people toward, well, either self-resolution or simply abandoning complex claims.
And this pressure point is contributing to a philosophical shift we're seeing.
Yes, captured by the phrase family law for family life.
This moves the legal mindset away from focusing purely on conflict resolution, the pathology of family breakdown, and toward a more anticipatory, constructive approach.
Precisely. Traditionally, family law is reactive. The new agenda emphasizes front-loading the legal reality. It suggests that advice needs to be communicated at the beginning or during relationships, not just when they collapse.
So what does this all mean? The new role of the family lawyer isn't just about picking up the pieces. It's about front-loading that legal reality, acting almost like a financial pre-counselor.
That's a good way to frame it. It's about proactive legal literacy. People are often genuinely surprised by the financial scope of marriage. For instance, courts having the power to adjust assets that were inherited or pensions or order long-term maintenance.
Right.
By making these default legal norms public knowledge, individuals are empowered to make informed decisions and, crucially, know how to frame their nuptial or cohabitation agreements effectively.
We've uncovered some significant geographical variation today. The three legal systems vary dramatically, particularly in Scotland's distinct recognition of cohabitation rights and its firm 3-year limit on spousal maintenance, which contrasts so sharply with the potential for those long-term, even lifetime claims in England and Wales.
And that contrast leads us to the heart of the current modernization movement in England and Wales. The forthcoming consultation is ambitious. It's aiming to balance fairness, certainty, and autonomy for modern families.
And the trend is already there.
The legal trend is already visible. You look at high-profile cases like Radmakers v. Granatino, which establish that prenuptial agreements carry magnetic importance in England unless they're unfair. This shows a clear desire for legal certainty and respect for informed personal choice.
Thank you for sharing these sources and guiding us through this challenging legal geography for this deep dive.
My pleasure. And a final provocative thought for the listener. We know the law is shifting to prioritize certainty and informed choice, evidenced by the power now given to nuptial agreements in England. If the system is moving toward autonomy, what is the legitimate argument for keeping lifetime financial claims open at all? And is there a moral or economic case for standardizing the definitive Scottish clean break principle across the entire UK to provide financial finality to divorce?